So the meaning of risk, yeah. So we are talking now about risk. Risk is the obligation to bear losses caused by an event outside the fault of one of the parties. Ya. Risiko, ya, adalah kewajiban untuk menanggung kerugian karena suatu peristiwa di luar kesalahan. So we learned about force majeure, right? This is related to the force majeure. And on the fourth point, you see that the risk is an effect of force majeure. Yeah, when compensation is an effect of breach of contract. So risk is due to force majeure, or as a result, or as a consequence of force majeure, right? When compensation, when you are obliged to pay losses and everything, that's the effect, or that's due to, or that's because of you're violating a contract, right? Breach of contract. Risk is based on the occurrence of an event beyond the fault. Okay, that is clear, yeah? It's outside the fault of one of the parties. Risk is stipulated under Article 1237. Okay, let us see. 1237. Please open up so you can also see the Indonesian version. This is about the obligation to deliver something, ya, tentang perikatan untuk memberikan sesuatu, right? Yeah, there is obligations to deliver something, there is obligations to do something or not to do something, right? So this is in the context of delivery of something, right? Obligation to deliver something. 1237. If there is an obligation to deliver something, then that thing or good is under the liability of the creditor since the day the obligation is born. Dalam hal adanya perikatan untuk memberikan suatu kebendaan tertentu, kebendaan itu semenjak perikatan dilahirkan adalah atas tanggungan si berpiutang. Ya. Semenjak perikatan dilahirkan adalah atas tanggungan si berpiutang. Okay. So this is one of the clauses in general, yeah, about risk, yeah. Later we will talk about the risk in sale and purchase, yeah, risk in lease agreement, and risk in borrow and use agreement, yeah. But this is in general, yeah. So the liability is the creditor. Right, the creditor means the party who is entitled to receive the thing, right? To receive that good, actually, yeah. So we will see how this clause is interpreted later on. Okay, now talking about risk, there are, we can say, we can categorize those risks, yeah, even though they are not stipulated in the ICC, yeah, we cannot find it, but we just can categorize it so we understand their differences. So 4 types of risk, yeah: accidental risk, pure risk, yeah, namely risk that only causes possible losses, such as the risk of fire, natural disasters, and theft. This risk only has the possibility of loss and has no possibility of profit. Okay. Intentional risk or speculative risk. Yeah, this risk, the risk that occurs, can be beneficial or not beneficial. Okay. If both possibilities exist, then it is said that the risk is speculative. Yeah, how the risk is beneficial? Yeah, I don't understand it. Yeah. How they say that the risk can be beneficial. Yeah, perhaps beneficial to the other party, yeah, to one of the parties. Fundamental risk, this is a risk that is likely to arise in most members of the public. So it will befall some members of the community. For example, the risk to the danger of war, earthquakes, and so on. Okay, and certain risk, a risk that affects individuals, meaning it only afflicts certain people, for example, death or disability. Yeah, we talked before. Oh no, we didn't talk yet. But the death or liquidation, dissolution, dissolution, liquidation of the company, bankruptcy of the company, for example, death of the person. Well, that's, you can see it as risk. Yeah, you can see it as risk, of course. But for dissolution, liquidation, bankruptcy, that's the risk for sure. But it can also be a breach of contract, actually. Yeah, because bankruptcy, you can do it voluntarily. Actually, you can go bankrupt by your own decision. And the risk, if we go back to the definition of risk, right? You still have to bear losses, yeah, even though the event is outside your fault. Yeah, you were not involved in that event, but you still have to bear the losses, right? That is what is called as risk. But if you go for voluntary bankruptcy, for example, well, it's not a risk. Yeah, you breach a contract, actually, yeah, because the contract says that you cannot do it without the other party's consent, for example. But if you refer to death, the death of a person, well, unless you kill yourself, yeah, that's intentional killing also, yeah. But if just death naturally, well, that's a risk, right? No one will know when it will happen, right? We are human, is very vulnerable. We can die anytime. Even though we have plans in this life, yeah, nobody cares, right? If there is a time that we should die, then we die. So you cannot measure it, right? So when it happens, it just happens. So that is a risk, yeah. But for bankruptcy, liquidation, dissolution, perhaps it's not a straightforward risk, yeah. It will depend on the situation. So this is the kind of situation that we will face, yeah, as lawyer, as legal practitioners, yeah. Of course, the legal issues that we are facing in this legal life, yeah, illegal world, it's not as easy as math. 1 + 1 = 2, yeah, because there are so many different factors, different situations, different conditions, yeah, that we have to put into consideration, yeah, before we analyze something. So under Article 1237, yeah, the word liability, tanggungan, yeah, you can see that it is tanggungan, actually, yeah, adalah atas tanggungan. Tanggungan, yeah, is like tanggung jawab, yeah. Yeah, in English you can say it's a liability. Menanggungan is liable. Bertanggung jawab is liable, yeah. Liability or responsibility, yeah, is interpreted as risk. Thus, in an obligation to give a particular item, if this item before being handed over is destroyed because of an event beyond the fault of one of the parties, this loss must be borne by the creditor, the party entitled to receive the goods. This is awkward, right? I mean, this is weird. It's not very, I mean, why the risk should be borne by the party receiving that good? Yeah. It doesn't seem right. Yeah. So that's why Subekti said that this clause is only applicable for a unilateral agreement. Yeah. So to be noted, Article 1237 is only applicable for a unilateral agreement such as grants agreement or hibah maksudnya ya, such as a grant agreement and borrow use agreement. So when you menghibahkan sesuatu ya, when you grant something, then this will be applicable ya, this clause 1237 ya. Memang di sini kan 1237 ini obligation to deliver something. But deliver something is many things actually ya. It's not jual beli kan. Sell and purchase is also deliver something. But well, the Subekti mentions that this clause 1237 is only applicable for unilateral agreement. It is not applicable to reciprocal. Reciprocal means that I have the obligation, but you also have the obligation. Yeah, that is reciprocal, right? So each party has rights and each has obligations. But unilateral, it's only one party has obligations and the other party only has rights, right? So that is called as creditor. The party who is entitled to receive the good and the party who will deliver the good is called the debtor, right? So the 1237 is only applicable for unilateral agreement, for hibah, yeah, for a grant. So to find the regulation regarding risk that is applicable to reciprocal agreement. So now we are moving to the risk that is for reciprocal agreement. Yeah, it is necessary to look for articles in the special section. A special section meanings, the special section in ICC under the agreement. Yeah, because the ICC also stipulates about sell and purchase, right? About a lease agreement, about loan agreement, about borrow and use agreement, about guarantee agreement. So they are the special sections. So we will look now how the risk is stipulated there. So we have the sell and purchase for 1460, and there are some others, yeah. And exchange tukar menukar, yeah, 1545, and lease sewa 1553. So let us look at it. Types of risk in sale and purchase. The risk of goods that are the object of sale and purchase is not the same. There are differences according to the nature and conditions of the goods. Regarding certain goods, nah, this is one is definite good ya. Maksudnya barang tertentu betul ini. Certain goods, barang definitif ya, barang tertentu. That the good from the time of purchase, the closing of the agreement, is on the buyer's risk. Although the handover has not been made, and the seller has the right to demand the price. Okay. Let's see. 1460. Jika kebendaan yang dijual itu berupa suatu barang yang sudah ditentukan, jadi it must be definite, maka barang ini sejak saat pembelian, ya, saat pembelian itu berbeda dengan saat penyerahan. Meskipun penyerah adalah atas tanggungan si pembeli. Ya. Jadi sejak saat pembelian adalah atas tanggungan si pembeli. Tanggungan lagi bahasanya di sini, ya, frasenya itu. So the liability of the buyer. Meskipun penyerahannya belum dilakukan dan si penjual berhak menuntut harganya. So we are talking about contract law, right? And you have to understand, yeah. I think I already explained several times in other classes, yeah, and other sessions. And there were some questions, I think, before about the difference between sell and purchase of property in Indonesia, yeah, real property, and the sale and purchase of movable goods and immovable goods. Real property is considered as immovable, right? You cannot move it. But other than that, you can say that they are movable goods. What is important to understand the 1460 is that you should understand that there is a concept of sale and purchase, right? When the sale and purchase occurs, and the answer is you see in 1457, What is considered as sale and purchase? Jual beli adalah suatu perjanjian dengan mana pihak yang satu mengikatkan dirinya untuk menyerahkan suatu kebendaan dan pihak yang lain untuk membayar harga yang telah dijanjikan. So and then 1458. Jual beli itu dianggap telah terjadi antara kedua belah pihak. Seketika setelahnya orang-orang ini mencapai sepakat tentang kebendaan tersebut dan harganya. So kesepakatan yang utama the consent or the agreement between them. Mencapai sepakat tentang kebendaan dan harga. So about the thing, the good, and the price. Even though that good has not been delivered yet, and the price has not been paid yet. Now you see in the 1459, hak milik atas barang yang dijual tidaklah berpindah selama penyerahan belum dilakukan. Nah, that's why there is a levering, there is a delivery, delivery. So this is obligatoir kan, obligatoir. Perjanjian jual beli itu obligatoir dalam arti it is binding already, but the transfer of right has not been made until the delivery is made. So the delivery is made. This refers to 612, 613, and 616, right? So if you look back to the 612, nah ini 612 talks about penyerahan kebendaan bergerak, kebendaan bergerak, right? Terkecuali yang tak bertubuh, you cannot see it. Dilakukan dengan penyerahan yang nyata akan kebendaan itu oleh atau atas nama pemilik, atau dengan penyerahan kunci dari bangunan dalam mana kebendaan itu berada. Penyerahan tak perlu dilakukan apabila kebendaan yang harus diserahkan dengan alasan hak lain telah dikuasai oleh orang yang hendak menerimanya. Okay, so you should understand that this is an obligatory concept. So even though you sign a sale and purchase agreement or you agree to buy something from the seller, the transfer of right of that thing that you bought, it has not been transferred yet until the delivery is made. The levering is made. And the levering under 612, you can see we can just give a key of the buildings. We can just give the actual delivery of the good. If you buy a handphone, the handphone is delivered to you. That's the transfer of right. Before it happens, the ownership of this handphone is still by the seller, not by the buyer. Because the transfer has not been completed yet. So if the transfer has not happened yet, so the good is still owned by the seller. This is important. Because if you want to understand the 1460, so that is why it is stated like this. Jika kebendaan yang dijual itu berupa suatu barang yang sudah ditentukan, maka barang ini sejak saat pembelian adalah atas tanggungan si pembeli. So if we agree on something and what I want to buy is definite or certain, it means that thing, that definite thing is my liability, even though the delivery has not been made. And the seller has the right to demand the price. So the delivery has not been made, right? But I still have to pay the price. So when will it be made? Perhaps in the middle of the payment or at the end of the payment after I fully pay everything, right? So it's based on the agreement. And now we see on 1461. Jika barang-barang tidak dijual menurut tumpukan tetapi menurut berat, jumlah atau ukuran, maka barang-barang itu tetap atas tanggungan si penjual hingga barang-barang ditimbang, dihitung, atau diukur. Nah, dia juga ngomong tanggungan di sini ya. Sekarang dibalik nih, tanggungan si penjual. Kalau 1460 tanggungan si pembeli. Ini untuk barang tertentu. Tapi kalau 1461 kan artinya bukan barang tertentu nih, tapi yang diukur menurut berat, jumlah, atau ukuran ya. Artinya barangnya banyak nih dalam 1 kilo gitu kan. Atau 1 pak, 1 apa lagi lah. Nah, lalu 1462. Jika sebaliknya barang-barangnya dijual menurut tumpukan, maka barang-barang itu adalah atas tanggungan si pembeli meskipun belum ditimbang, dihitung, atau diukur. So I think for 1462 is just the explanation of 1416. Yeah. So either it is a certain or it is not based on measurement, yeah, based on weights and everything. So that if that is the thing that you buy, you are liable. Yeah, I mean the buyer is liable. Yeah, but if the thing that you will buy should be measured in weight like this, yeah, then it is the seller's liability. So 1460, 1461, and 1462 are all related actually. But the main important clause about the risk in sale and purchase, I think, is 1460. And 1460 is a bit awkward also. Yeah, that's why when we talk about the 1237, it is interpreted that the 1237 is only applicable for a grant, yeah, hibah, a unilateral agreement. But for 1460, there are some limitations of the interpretation. And then later on, we will look that even this clause is regarded as not applicable by the Supreme Court, yeah, in around 60s, yeah. I think it's 1963. The Supreme Court issues some circular letter stating that the 1460 is not applicable anymore. Yeah, so it's kind of weird actually. So let's see. So if the sold good is a good that is already determined, then that good falls under the liability of the buyer from the time of purchase, notwithstanding that delivery has not yet taken place. And the seller is entitled to demand the purchase price. According to that article, the risk is placed on the buyer, who is the creditor of the good he buys. If the seller goes bankrupt or has its property confiscated, then that item is still considered as the property of the seller. Now, this is what I'm trying to say before. If there is no delivery yet, it means that the property is still owned by the seller, even though there is a sale and purchase agreement already, yeah, because it's an obligatory, yeah. Sale and purchase is an obligatory. It's not. It differentiates the obligations to deliver and the delivery itself, yeah. It differentiates so that there is a levering in the obligatory agreement. It's different in the sale and purchase of real property, immovable goods, ya, seperti properti tanah dan bangunan, ya. We use hukum adat, right? Customary law, and under customary law we don't recognize obligatory concept. This is Dutch law, and even the Subekti said that this is not even very pure anymore, because the Code Civil, yeah, the Code Civil is does not differentiate this, yeah. But the ICC, Indonesian Civil Code, makes it different. So hukum adat doesn't recognize this. So when you transfer the real property, when you sign akte jual beli for tanah dan bangunan, yeah, it's already transferred. at the time of signing of sale and purchase, because they don't differentiate between the levering and the obligatory of the sale and purchase. It's not differentiated. So the levering happens at the signing of sell and purchase deed before the PPAT. Yeah, so it just happens. So don't be confused. Yeah, don't be confused. What I'm trying to explain is important, because one is under Dutch law, one is under Adat law. Yeah, so it's different perspective, different mindset, and sometimes we are confused with it. Yeah, but we cannot. Well, sometimes like this. Yeah, agreement for sale and purchase of property, you should refer to 1338, 1338 and 1320 or not. Well, we are referring to hukum adat kan. There is no 1320, there is no 1338 under hukum adat. It's a different kind of agreement. So it's not correct actually if we analyze the agreement for real property transactions under ICC, because it's not under ICC, it's under hukum adat. Yeah, well, ICC regulates other than immovable goods, right? The movable goods are still regulated under ICC, and we are bound, we are subject to it, but not for real property. It's under hukum adat. But of course, the variations of real property transactions are many, right? The akte jual beli di depan pejabat pembuat akta tanah are based on hukum adat for sure. But when the people signs perjanjian pengikatan jual beli, for example, yeah, PPJB, perjanjian pengikatan jual beli or conditional sale and purchase agreement, what will it be then? Will it be under ICC or hukum adat? So of course it cannot be under ICC anymore. It cannot be under hukum adat anymore. It should be under ICC, yeah, because hukum adat does not recognize conditional agreement, right? I don't know. I never heard that there is a conditional agreement under the hukum adat. So conditional agreement is a ICC concept. It's a civil law concept. It's not hukum adat concept. So of course, when the parties sign PPJB, you cannot then refer it to hukum adat. It is not hukum adat. Yeah, it is of course ICC. So there are variations, yeah, of course. But we should understand that the jurisdiction, the division between the movable transaction, movable good transaction, and immovable transaction are different. Yeah. Under the real property, we already have Undang-Undang Pokok Agraria. Yeah, so that's the governing law. Now, coming back to this, the third point. If the seller goes bankrupt or has its property confiscated, then that item is still considered as the property of the seller, of course. And we are talking about the movable goods, yeah, not the immovable goods in this third point. Like I said before, if the immovable good is already transferred, so no issue. Unless you only sign the PPJB, of course, it hasn't been transferred yet. But when you already sign AJB, that's transferred already. But this is talking about the movable goods. When you sign an agreement for the movable goods has not been transferred to you, has not been delivered to you, it will mean that you are not the owner of that good. So who is the owner then? The owner is still by the seller. Now, when the seller goes bankrupt, or the seller dies, for example, if the seller goes bankrupt, it means that the assets will be taken over, will be confiscated, and for the benefit of the creditors, right? So this will arise a problem because the property is considered still as the property of the seller. Well, that's the legal thing. We cannot do anything about it. And this is similar actually to the so many developers in Indonesia, real property developers, yeah, I mean developer apartemen, mostly developers apartemen. They are breaching the contract, the PPJB, they're breaching it with their customers, and then their company is becoming bankrupt because of it. And what happens to the customers then? They are suffering, right? They have paid, perhaps, maybe most of the purchase price, yeah, perhaps 50%, maybe more, even already fully pay it, right? But the company goes bankrupt, the company doing the project. If the company goes bankrupt and there is still yet signing of AJB before PPAT, then it will be considered as the property of the seller. It is not the property of the buyer. So you can imagine that the apartment, even though you already pay, you already pay maybe more than 50%, when the company, the developer company, goes bankrupt, you cannot say that it is already yours. And then who is authorized to continue or discontinue this transaction? That's the receiver. That's the curator. Curator will have the authority to decide whether this project should be continued or stopped and then sold to the other party. Well, it happens. Sometimes there is no buyer anymore. Sometimes the company just goes bankrupt and everybody loses. Everybody suffers, especially the customers, right? The customers, maybe they pay 100%. Let's say the amount that they have already paid is 100%. Because of the bankruptcy, they might be able just to get 20%, 30% out of the money that they have paid before. So they lose 70%, 80%. And that is after the long period, maybe 3 years, 4 years, 5 years, being involved in the creditors meeting and everything. So it's a pain in the ass. I mean, it's a really painful journey that no one would like to experience. I think that's one of the problems in our legal system about bankruptcy. It should not happen like that. But the good news is that the Supreme Court also gave, like, in 2016, they gave what do you call it? Rumusan kamar, Rumusan kamar. They said that if the buyer already fully pay the property price, and then the physical possession already been transferred to the purchaser. Jadi konsumen udah bayar lunas nih, lalu penguasaan fisik apartemen itu sudah diserahkan, sudah memang dikuasai oleh si customer, then it is considered as outside the asset of the seller or outside the asset of the developer. So it means that you can carve it out. Kamu bisa keluarkan tuh aset itu. Kalau yang tadi kita bahas kan semuanya dianggap masih aset penjual. Tapi kemudian Mahkamah Agung memberikan pandangan bahwa ini bisa dikeluarkan selama it has been fully paid and you already possess it physically. This is a good news actually. Good news for the people, for the customers. But this is through Supreme Court, so you cannot use it as legal analysis. Perhaps you can use it as reference, but this is applicable to the courts, right? When you file the claim to the court or when you defend yourself at the court, then this is applicable. Okay, there is a peculiarity. We talk about it. And the second point, we also talk about this. The civil code in a certain sale and purchase, the right of ownership have been transferred at the closing. This is what happens to the real property, hukum adat. While in the ICC, in a sale and purchase, the right of ownership is only transferred if the goods are handed over. Jadi penyerahan apa sih istilahnya tuh, the transfer of right ya, the transfer of right. Jadi pemindahan hak itu baru terjadi setelah penyerahan. To reduce such peculiarities, Article 1460 is commonly interpreted narrowly by scholars and jurisprudence. First, the definite good, the certain good, refers to the appointed and chosen good by the buyer and can no longer be replaced with other good. Jadi, the definite good barang tertentu, right? It must be very, very specific. It is not just so it must be like there is no other copy of it, right? It's different than if you choose kursi kayu misalnya, kursi kayu, wooden chair. This model of wooden chair, well, it's easy, right? You can just produce another one with the same model, but this one is you cannot do it. It is very, very specific, can no longer be replaced with other good. So it's very, very specific. Perhaps it's like a painting. I think it's one at a kind, maybe like batik shirt. It's one of the kind, right? Batik shirt. So the buyer is deemed to temporarily deposit such bought good at the seller until its delivery. So referring to the 1460, the buyer is deemed to deposit, yang maksudnya dititipin itu barang sampai diserahkan. Jadi kan dia udah sepakat jual beli, oke, belum ada penyerahan. Nah, selama belum penyerahan itu dianggap dititipkan. Second, that provision is only applicable if there is a permanent or absolute force majeure, meaning that bought good is destroyed, gone, before it is delivered. This is not applicable when the force majeure is not absolute. So the 1460 is interpreted narrowly. There are two conditions. The first one is that it must be definitive. The second one it has to be related to the permanent or absolute force majeure, meaning you cannot. It is just destroyed. You cannot deliver it anymore. The painting is gone. The painting is on fire, so I cannot deliver it to you anymore. But if it is not absolute, the 1460 is not applicable. So it can be concluded that the responsibility for the goods must be borne by the seller as long as the ownership has not been transferred, who is still considered as the owner of that goods. And according to circular letter, this is what I'm saying before, it's 1963, Article 460 of ICC is no longer valid. SEMA states, is it not more appropriate? Bukankah lebih pantas that the liability or risk for the loss of good that is promised to be sold but yet to be delivered must be equally borne by the parties? And if yes, to what extent? Jadi sama-sama maksudnya hakim nih, hakim agung equally borne, sama-sama harusnya. Bukankah lebih pantas? Jadi Supreme Court surat edaran Mahkamah Agung meniadakan keberlakuan 1460. But we will see later in the court decision, it doesn't mean that it is altogether inapplicable at all. It doesn't mean that you cannot refer to this article at all. You can still refer. It can still be considered by the judges. But the concept in here, I think, is the 1460 cannot be seen anymore as the sole responsibility by the buyer, because the original version is there is a sole responsibility, right? It is the buyer's liability, right? But according to this Supreme Court and according to Subekti says, it has to be equally borne, because Subekti also has narrow definitions about 1460. Otherwise, if determination of risk is according to the Article 1470 of ICC, if at the time of sale the goods sold have been completely destroyed, then the purchase is void. If only part of it is destroyed, then the buyer may cancel the purchase. or demand the remaining parts and order the price to be determined according to the balance assessment. Yeah. If it is completely destroyed, the purchase is void. I think this is the same applicable with the lease, yeah. Because if the goods is no longer exists, we cannot do the purchase, right? But if it is partially destroyed, then the buyer may cancel the purchase or demand the remaining parts and order the price to be determined, ya. Kalau hanya sebagian ya bisa dibatalin juga. Kalau memang sebagian itu adalah kesatuan, nggak bisa dibeli juga. Tapi kalau sebagian itu mungkin komponen yang memang bisa dilepas, ya mungkin dia tetap akan lanjut beli. Now, in tukar menukar, exchange. This is actually the 1545 clause is actually recommended by the Professor Subekti, because he said that this is a very good idea of a clause, of a provision to be implemented. Yeah, in the fourth point, I mentioned that this provision should be considered as the rule of thumb for the reciprocal agreement. So let's see, if certain goods which has been agreed for exchange is destroyed beyond the fault of the owner, then the agreement is considered void. And parties who have fulfilled the agreement can claim back the goods which he has delivered in exchange. Let's read in bahasa. Jika suatu barang tertentu yang telah dijanjikan untuk ditukar musnah di luar salah pemiliknya, ya sama kan, itu masalah risiko kan di luar kesalahan, ya, maka perjanjian dianggap sebagai gugur, dan siapa yang dari pihaknya telah memenuhi perjanjian dapat menuntut kembali barang-barang yang ia telah berikan dalam tukar menukar. In this article, the burden of risk is placed on each owner of the goods. In case one of the goods is lost, caused by an event outside the fault of one of the parties, then the other parties may request the return of the goods he already gave. Yeah. Well, while in 1460 is the liability of the buyer, right? Yeah. But in here, it is not the burden to the other party. Yeah. When there is an obligations to do something or to give something, because it is tukar menukar kan, tukar menukar barang. Apa yang sudah saya kasih, saya tetap bisa minta lagi. Ya. So, musnahnya barangmu itu bukan kesalahan saya toh. Jadi nggak bisa dibebankan kepada saya. Karena kalau dalam jual beli kan ini nggak begini nih. Kalau jual beli kan barang yang saya jual tiba-tiba musnah, itu menjadi kewajiban Anda pembeli. 1460, right? But 1545 kan nggak ngomong begitu ya, karena memang ini bukan jual beli, konsepnya memang beda. Tapi intinya, karena ini reciprocal, Anda harus lakukan sesuatu, saya juga harus lakukan sesuatu. If what you did to deliver the good and the good is destroyed, and I have delivered my obligation, yeah. Well, you have to bear your losses, yeah, because your good is gone, right? It's lost. So you bear it. Then what I have delivered, I will take it back. Yeah. So actually, we cannot do the exchange because of it, right? We cannot proceed with the exchange because your good is lost. But it also means that the party that his thing lost will have to bear the losses, right? Well, it's not an easy issue, yeah, actually, yeah. It's not easy to balance, yeah, who will bear what and how much. I think this one is similar. The risk arrangements in the lease, yeah, is stipulated under Article 1553 if during the period of the rent, the lease property is destroyed completely due to an accident, the rent agreement becomes null and void. Ya, kalau ini null and void ya, as if it will never happen. Let's see in Indonesian. Jika selama waktu sewa barang yang disewakan sama sekali musnah karena suatu kejadian yang tak disengaja, due to an unintentional event ya, not an accident. Unintentional event. Maka perjanjian sewa gugur demi hukum. Gugur demi hukum. There is no explicit phrase of liability, ya. Nggak ada kata tanggungan di sini. But one can understand that the provision implies risk. Ya, tersimpulkan aja. From the phrase null and void, gugur demi hukum, one can see that each party cannot claim the other party for that matter. Thus, the loss due to destruction is borne entirely by the owner of the goods. Yeah. That is why in the lease agreement, there should be a insurance for this kind of event. Yeah. Well, every risk, that's why there is an insurance. Yeah. Because insurance is relevant to cover risk, right? Life insurance to cover risk when we die, for example, right? Health insurance to cover risk when we are sick. This kind of insurance cover the building destruction risk, for example, perhaps due to the earthquake, or due to explosion. Yeah, the building is partially destroyed. Then who has to rebuild it? Yeah, there's always the problem. Yeah, who has to rebuild the property? The owner may not have the money for it. Yeah, so that's why they insure the building. When that happens, they will claim the insurance and then rebuild the property. Yeah, if there is no insurance, it will be very tough. Yeah. Some buildings in Jakarta, for example, when we saw that the building was on fire, yeah, due to many reasons. Normally, it happens to the old buildings, right? It was on fire, maybe because the electricity is not properly maintained. And then it was just laid out like that, yeah, without anything. They perhaps cover it, yeah, the burned part, yeah, but they don't really do anything about it. Quite a long time, maybe several years, until they do something about it. Yeah, so this is a huge risk, yeah, even though it doesn't happen a lot, yeah, but when that happens, it has a huge effect, yeah, to the property owner. So of course, if your property is gone, yeah, it's no point to have a lease agreement anymore. What can be leased, right? What can be rented when the property is gone? When you have a property, you lease it out, and then there is a war, bombing out your apartments are gone, right? And tenant who rented out before with you, well, cannot rent anymore, right? So what he has paid or she has paid, that's it. He cannot continue the rent, and then of course you have to bear the risk because of that bombing, for example, because you are the owner of it. So as stated, that the risk is the obligation to bear losses, yeah, even though it is outside your fault, right? So this is different, yeah, than the force majeure. Force majeure is something that outside your fault, yeah, you don't intentionally do it, right? It is unintentional and unforeseen, kan, kalau force majeure. You cannot expect it coming. Nobody knows when it is coming. So that's why you are not liable to compensate for losses, right? That is the force majeure. That's the defense style of legal claim. Right? Someone claiming you that you are not doing the contract's obligation, and then you will reply that I cannot do it because I suffer of force majeure. So I'm not obligated to pay compensation to you, right? This is the normal situation. Yeah. But the risk in here is it doesn't stop just on the force majeure. Then you are not obligated to compensate. Of course, you are not obligated to compensate. But what you suffer as losses, you still have to bear, right? That's the risk. Like in the lease agreement, the lease agreement that we just spoke about, the landlord, the property owner, will have to bear the losses, especially if he doesn't have the insurance. He cannot claim the insurance. He has to rebuild it himself with his own money. So that is the risk he has to pay. He has to bear. The same thing applies to the exchange, right? For the exchange, if the good that would like to be exchanged gone, the owner will have to bear the losses, right? What is different is with the sale and purchase, yeah, because the sale and purchase is just different than the exchange and the lease, yeah. Even though the ownership still lies on the seller, but when the when the sale and purchase happens, even though there is no transfer of right, there is no delivery yet being done, the liability is already transferred to the buyer. So that's why this is a bit peculiar, a bit weird, and that's why the Subjekti also says that this clause is narrowly interpreted, yeah, with two conditions that we talked about before. And then of course we also talk about the Supreme Court actions, yeah, that they decided that this clause is not applicable anymore because it doesn't seem right, yeah. What the Supreme Judges mentioned, that it is more appropriate if the risk is equally borne, ya. Jadi ditanggung baik oleh penjual maupun oleh pembeli secara proporsional, ya, bukan cuma pembeli sepenuhnya. And that happens whether or not there is a force majeure, yeah, because the risk is something you have to bear even though it is not your fault, yeah. Even though there is a force majeure, but you still have to bear that kind of losses. That's called risk. So that's the difference between your defense style. If you are claimed and then you defend yourself that I am not obliged to compensate you because I suffer a force majeure, yeah. But if you lost something due to force majeure, of course you will not be able to deliver or to do your obligation. This is one thing, right? You cannot do it. You cannot do the obligation of the contract. Like the case of the lease, after the property is gone, you cannot do the obligations to rent the property any longer, right? Because the property is gone. So what can you do? But that is because the force majeure, of course, it's not due to your fault, right? It's just gone because of fire or because of the act of God or because of the war, bombing and everything. You don't do anything about it. You don't expect it coming. It's just being done. The property is gone. I cannot continue my obligation, right? So if you claim me and say that I'm violating the contract, I will say that I cannot do it because of the force majeure. That's the defense style that we talked about last week. But we are talking today is about the risk. So even though you can still be claimed and you can still defend yourself because of the force majeure, in any event you will still have to bear your losses, right? That's called the risk, yeah. Even though it is not your fault, you still have to bear it anyway. That's called as risk, risiko, yeah. So your property is gone. That's the risk of of having a property. Ya, that's the risk of having a property actually ya. Kalau kita punya sesuatu kan bisa hilang kan memang. Ya artinya kan itu risiko yang kita harus hadapi setiap saat kita mempunyai sesuatu kan. Ya. Apa yang tercatat di internet, apa yang tercatat di sistem aja bisa hilang. Apalagi yang fisik kan. Kalau fisik hilang, diambil orang, dicuri, itu kan risiko semua. Hancur, jatuh, rusak, kan risiko tuh. Nah itu risiko juga kan. Bukan kita yang rusakin ya, tapi kan terjadi aja rusak sudah. Nah itu kan bisa dalam hubungan hukum, bisa juga enggak ya. Kalau enggak kita sewain kan enggak ada hubungan hukum ya. Tapi kalau rusak kan bisa terjadi anytime. Apakah itu melalui sewa atau tidak. So that's the thing ya. It's different than force majeure. So yeah, we can refer back again, of course, to 1244 and 1245 to refresh our mind. You can see it yourself. Yeah, it's not necessary to discuss it here. So that's our point. So I think that's the conclusion. Yeah, risk is everywhere, right? What we can do is just mitigate the risk. Yeah, I mean minimize the risk, right? I just remembered we were talking about the right of ownership that we have in the system, right? Misalnya saham, obligasi atau apapun lah yang kita punya di sistem kan sekarang semua by system. Semua adanya di handphone, semua adanya di laptop. Tapi kan di kotak-katik sedikit aja bisa hilang itu. Atau ada di sistem ditulis 100 saham kita punya, tapi ternyata dicuri sama brokernya, ya. Tidak bisa tidak ada lah barangnya 100 cuma catatan. Itu kan juga bisa ya. Jadi memang kepemilikan kan secara fisik maupun secara tidak bertubuh ya. Sekarang kan makin banyak yang tidak bertubuh lagi ya. Maksudnya banyak sekali derivatifnya sekarang. Apapun kita bisa miliki ya. Dan itu tidak bertubuh, semua cuma catatan-catatan. Dan memang kita hanya mengandalkan orang yang punya sistem sebetulnya sih. Yeah, that's why I think that the regulation is important to control them and also to minimize the risk. Yeah, of course the regulation must consider there are risks, of course. Yeah, there are risks in everything, right? But how to minimize those risks? Yeah, I think that's the important thing. That's our role as lawyer actually. That's our role as lawyer. We should remind our clients that there is risk or there are risks, yeah, and how to mitigate those risks. Yeah, the simplest thing is insurance. Yeah, one of the simplest thing to recommend is to take out an insurance. Other than that, maybe the balancing of obligation in the agreement. Yeah, we can stipulate something that if this happens, then perhaps it should be equally borne. Yeah, or maybe additional mechanism just to minimize the risk. Yeah, additional mechanism in place in the contract to minimize the risk to happen before. Yeah. So yeah, that is our thing. This is the risk of the rent we talk about, and there is a risk also of sell and purchase. So the destroy of the goods can always happen, right? Barang musnah, benda musnah itu bisa terjadi dalam segala hal kan, dalam jual beli, dalam tukar menukar, dalam sewa. But different agreement has different risk. Yeah, different agreement has different risk. Yeah. So, for example, in the construction contract, there is a risk that there might be a worker dies in the site, right? Because they have to climb up a tall buildings or a tall structure, and then he falls down and dies, right? That is risk. or perhaps there is a guest coming there, or there is a people outside. And if you see the construction project, the big construction project, they will use tractors, yeah, huge engines, yeah, to move object here and there, right? And then that object falls outside the site, for example. Outside the site, the object falls and then hit a person, and then the person dies, or hits a house and the house is destroyed, something like that. So there are so many risks, and there should be insurance for that also. Yeah, that's why sometimes it is called as contractors all risk insurance. And also there is a third party liability insurance. Yeah, if the object hits a person or hits a house, that's a third party liability insurance actually. But the contractors all risk insurance is within the site. Yeah, or maybe it can also cover the third party liability, but normally the insurance covering everything happens in the site, and everything happens in the site and outside the site. Yeah, so different agreements, different risk. Yeah, different transactions, different risk. Yeah, we should understand that. And actually it is not easy, yeah, to identify the risk. Yeah, sometimes it's not easy, sometimes, especially if we are new at it, yeah, we don't know the risk. Yeah, that's why it is good when you become a lawyer. You should focus on one thing, or maybe two things or three things. Yeah, but focus narrowly, so you really understand your field. Yeah, you specialize on it, so it grows better and better. Yeah, you can identify the risk in this project. Yeah, you can know what to do when this happens and that happens. You know what to draft in the agreement from the beginning. Yeah, just to because you focus on that sectors, because you focus on that industry, focus on that activities. Yeah, so you understand it very well. Yeah, that is important also, I think. Yeah, as lawyer.